The second legal issue raised by the second set of proceedings concerns the proper construction of Clause 8, and in particular the applicant's contention that the abolition of one district and its amalgamation into another district effectively abolishes the second district as well, with the result that two districts are abolished and Clause 8 is triggered. The fundamental problem with this construction of Clause 8 is, as I indicated to Council during the course of argument, and that is that if that were the intention of the legislature, it is impossible to reconcile with the terms used by Clause 8. Clause 8 provides, and I quote, "Where the Advisory Board recommends to the Minister the making of an order to abolish two or more districts and amalgamate them, that is, those districts, into one or more districts, the Board is to give notice," etc. The applicant's proposition is that where one district is abolished and it is amalgamated into one or more districts, then because those other districts are also effectively abolished, the clause applies. But of course, if that was what Parliament had intended, then the number 2 in the clause would serve no purpose whatsoever. In any circumstance in which a district is abolished, unless the district is no longer to be subject to local government because, for example, all the inhabitants have left, necessarily that district will be amalgamated into one or more other districts. So the requirement that there be the abolition of two districts can only serve to indicate a parliamentary intention that there must be more than one district which is to be abolished and amalgamated into one or more other districts because, as I've mentioned by definition, every time a district is abolished, if it is to remain subject to the Act, it must be amalgamated into one or more other districts. The applicants rely, in support of their contention, upon section 1.32b of the Act, which I mentioned earlier and which refers to the intended result of the Act in terms of greater community participation in the decisions and affairs of local governments. There are two reasons why that reliance is misplaced. Firstly, it appears to me to misconstrue the subsection. The subsection is to be found in a paragraph of the Act. The paragraph is to be found in a subsection of the Act which has 4 provisions, all of which appear to me by their natural and ordinary meaning to be concerned with the relationship between local government and the ratepayers or residents of the areas governed by local government. That is apparent from subclause C, for example, which refers to the greater accountability of local governments to their communities. The issue before the court is not concerned with the relationship between local government and their communities, but rather with the structure of local government in the state. The second reason, and it's therefore in my view that the provisions of Clause 2, subclause B, shed no particular light on the proper construction to be given to Clause 8 of Schedule 2.1. The second reason that is so is because clearly Parliament, by Clause 8, has chosen to limit the circumstances in which a poll can be required by affected electors. Thus, if it were the intention of Parliament to facilitate greater community participation in the decisions and affairs of local government by providing the opportunity of a poll in any circumstance in which one local government district was abolished, then plainly the Parliament could have said so. It can't possibly be the parliamentary intention that every elector affected by the abolition of a district in which they reside will have an entitlement to request a poll, and that is clear from the use of the number 2 in Clause 8. The question then is, what did Parliament mean by the words which are used in Clause 8? To my mind, the meaning of that clause is clear. 2 districts have to be abolished, and both abolished districts must be amalgamated into one or more other district, as the plain and ordinary meaning of the clause attests. Abolition of one district, as I've mentioned, will almost always require its amalgamation into one or more other districts, unless the area concerned is no longer to be the subject of local government, but Parliament has clearly decided not to include that circumstance within Clause 8. That construction of the clause is reinforced by a number of aspects of Schedule 2.1. Firstly, as I've noticed, the term the districts is placed in parentheses to indicate clearly to the reader that it is a defined term where used elsewhere, and it's a term that is defined to refer to the 2 or more districts that are to be abolished, by the making of an order. That defined term is used again in Clause 8, Subclause 3, which refers, and in the context it's clear that the reference is to the electors of one of the two districts to be abolished, and similarly in Clause 10, 2a, where the phrase the districts is used again, it clearly connotes the electors of one of the two districts that are to be abolished. So plainly the definition of that term connotes that there must be two or more districts which are to be abolished. Second consideration which points in favour of the construction of which the Minister contends is in Clause 8.1 itself, where it refers to the requirement of the Board to give notice to affected local governments, affected electors, and to the other electors of districts directly affected by the recommendation. Now, plainly in that context, where there is a distinction drawn between affected electors and the other electors of a district directly affected by the recommendation, there must be a distinction between those two classes of elector. It seems to me the distinction is clear from the structure of the clause itself, and that affected electors is a reference to the electors in the two or more districts that are to be abolished, and the other electors of districts directly affected by the recommendation are the districts into which one or more of the districts to be abolished is to be amalgamated. And that again is consistent with the notion that there must be two districts which are to be abolished, and those districts do not include districts into which the abolished districts are to be amalgamated. It's also significant that the clause distinguishes between, it's also significant that the clause uses the word abolish. That term is not defined, but it draws its meaning, I think, in Clause 8 from its reference, the way in which it's used in Clause 2.1. As I mentioned earlier, Clause 2.1 provides that the Governor may make recommendations doing various things, including changing the boundaries of a district, which is separate and distinct from an order abolishing a district. The distinction between those two things is, I think, relatively clear from the structure of the Act, because when a district is established, a local government is created in respect of that district by Section 2.5. So, when a district is abolished under Clause 2.1, the local government body that previously existed in relation to that district ceases to exist. On the other hand, when an order is made changing the boundaries of a district, the local government body continues to exist under Clause 2.5, but in respect of a different area. So there is, to my way of thinking, a clear distinction drawn by the structure of the Act between abolition on the one hand and a change of boundaries on the other, and the consequence of that distinction is whether or not the local government body relevant to the district continues to exist. So it seems to me to be clear that the Act does distinguish between abolition on the one hand and boundary changes on the other, for the various drafting indicators to which I've referred. That reinforces my view of the plain and ordinary meaning of Clause 8. That view reinforces the position taken by the Minister, and it therefore follows that the recommendations made, being proposals 5 and 17 relating to the City of Subiaco and the Shire of Serpentine Jarrahdale, do not come within Clause 8 of Schedule 2.1, and no poll is required in relation to those recommendations. So for that reason, the second proposition embodied by the applicants within the second set of proceedings must also be dismissed, with the result that those proceedings should be dismissed. So for those reasons, I would dismiss both sets of proceedings. Mr Bidder?
Please, of course, I move in each proceeding the floor orders that the application be dismissed and the applicants pay the first respondent's costs to be taxed if not agreed.
Mr Shanahan?
Nothing to say about that, Your Honour.
Very well. There'll be orders in those terms. Court will now adjourn.
All stand. This honourable court is adjourned.